Welcome to the deep dive. Today, we are strapping in to navigate, well, a true administrative labyrinth. I'm talking about the global rule book emerging for artificial intelligence. For any modern enterprise, compliance is just no longer a simple tick box exercise. The world's AI regulations are fracturing so fast that yesterday's playbook won't just be inefficient, it might be legally and financially dangerous.
That is the critical takeaway. It really is. Our sources today function as an urgent strategic briefing for 2026 data law trends. They show a world where regulatory predictability has just vanished. It's been replaced by these intensely divergent rules, intensifying enforcement, and competing national agendas.
And we're going to zero in on a case study.
A really compelling one. Vietnam's new comprehensive law on AI. This is a perfect example of how strategic Asian nations are designing their own digital governance paths, often conflicting, directly with established Western models.
Okay, so our mission for this deep dive is to deliver a shortcut to understanding this chaos. We need to unpack the ambition behind Vietnam's new law, assess the significant compliance burden it immediately places on global businesses, and then connect this local development to the massive, almost chaotic regulatory fragmentation we are seeing globally, from Washington, D.C. all the way to Brussels. This isn't just theory. This is about minimizing your legal exposure in the next 2 years. Let's start with the sheer scale of Vietnam's ambition. I mean, they are playing a serious game here.
Absolutely.
Having already surpassed Singapore's GDP by 2020, they are now laser-focused on becoming a dominant AI innovation center in the entire ASEAN region by 2030. This push is codified in a national strategy document going all the way back to January 2021.
And the rhetoric is stunning, isn't it?
It is. Their Minister of Science and Technology stated that AI's potential effect is, and I'm quoting here, mightier than nuclear power. That tells you this isn't just bureaucracy, it's a national priority.
That powerful statement just underscores the state-led techno-developmental model they are pursuing. But to put this in context, according to the 2024 AI Readiness Index, Vietnam currently sits at 51st globally. So while they are ahead of the lower middle-income average, they clearly still lag behind established regional leaders like South Korea and Singapore.
Right.
So this new law on AI, which was passed December 12, 2025, and becomes effective March 1, 2026, is the essential legislative tool they are deploying to assert digital sovereignty and, rapidly bridge that innovation gap.
So if they are playing catch-up, what are the core philosophical principles guiding this new framework? Are they just copying the EU model?
Not exactly, no. They are certainly leveraging the global risk-based movement, but their law is fundamentally structured around 4 driving principles that serve national goals. First, AI must be human-centered.
Meaning human accountability is still paramount.
Exactly. Second, it must rigorously prioritize national interests and security. Third, it mandates fairness and transparency. And fourth, and I think this is the most revealing part, it emphasizes self-sufficiency and comprehensive, sustainable development. They want to master core technologies and reduce their reliance on foreign tech providers.
Okay, that focus on security and self-sufficiency, it suggests they've taken the global risk-based approach, but then adapted it specifically for their own strategic needs.
They've tailored it.
So how is that 4-tier classification system structured? And where does it diverge from, say, the EU's?
Well, the divergence is really in the application and the specific prohibitions. The 4-tier system starts with unacceptable risk. These systems are strictly prohibited because they threaten national security, social order, or human dignity.
So things like deepfakes.
Deepfakes specifically designed to destabilize public opinion, yes. Also, large-scale facial recognition without explicit consent, or systems designed to manipulate cognitive behavior. The focus here is clearly national stability.
That strong prohibition list, which, hits right at the heart of manipulation, sets a very firm line immediately.
Below that is the high-risk tier. This covers AI systems used in critical sectors. So think finance, healthcare, education, infrastructure, and the justice system. For these, mandatory government assessment and pre-market approval are required before you can deploy them.
Wow, pre-market approval. That's a massive barrier to entry, especially for foreign providers who are used to, much lighter oversight.
Precisely. The third tier is medium risk, which demands clear transparency and labeling obligations. Users have to know when they are interacting with AI-generated content or systems. And the final tier, low risk, is reserved for voluntary compliance and just general monitoring.
So what this ultimately means for any global business operating in those high-risk sectors, let's say a foreign financial firm or a healthcare provider, is that correctly classifying your systems, That is the single most critical, urgent administrative task you have. Misjudging your tier shifts you from, voluntary guidance to mandatory detailed government registration. That difference is just colossal.
It creates a foundational requirement for continuous, documented risk assessment. Providers have to establish risk management frameworks and then regularly review them as the AI system evolves. That level of risk mapping and documentation is now the central cost of compliance in this new fragmented world.
And this process of identifying and assessing the specific level of risk in AI systems, especially when you're navigating unique national security requirements like Vietnam's, is exactly why robust tools and methodologies dedicated to reliable AI governance are paramount. If you are struggling to build a framework for continuous, auditable AI risk assessments that can satisfy these global requirements, you really do need a rigorous platform. You can check out www.airriskassess.com to help establish robust governance practices that can stand up to this kind of detailed regulatory scrutiny, no matter the jurisdiction. Okay, let's pivot from the stick to the carrot. Vietnam isn't just regulating, they're strategically incentivizing domestic development. What kind of financial support are they building into this law to help local companies compete globally?
They're backing this with state financial muscle. The law creates the National AI Development Fund. It's a special non-budgetary state financial fund designed to accept higher risks and flexibly allocate capital to promising domestic projects. They are also establishing AI clusters. These are innovation zones that offer priority access to national AI infrastructure, tax incentives, and crucial land use benefits.
So the goal is to master their own core AI tech.
Exactly, including large Vietnamese and ethnic minority language models.
And this is where we see some true strategic divergence, isn't it? Particularly around intellectual property rights, which has been a major point of friction globally.
Yes, what's truly fascinating here is the IP maneuver embedded in the draft law. It states that duplicating or extracting legally accessible copyrighted works for the exclusive purpose of training AI models is generally not considered copyright infringement. This is conditional, of course. You have to respect the owner's machine-readable opt-out right.
That is a significant exception to established Western IP norms. How does that decision connect back to their national strategic goals?
It's a direct accelerator for self-sufficiency. By providing this exemption, as long as the source material is legally accessible, they dramatically lower the legal friction and the cost associated with obtaining the massive quantities of data you need to train large domestic AI models.
So their local developers can scale quickly without getting bogged down in endless copyright litigation.
Right, and that contrasts sharply with jurisdictions that prioritize stricter copyright protection over broad data mining access.
Now let's talk practical obligations for foreign companies. Beyond the risk tiers, what's the enforcement threat?
The enforcement mechanisms mirror global trends. High-risk AI foreign providers operating in Vietnam must appoint a local legal contact point, and in some key cases, they actually have to establish a commercial presence. The teeth come from the penalties. For serious violations, the monetary fine for a large organization can be calculated based on a percentage of the organization's global revenue from the previous fiscal year.
That revenue-based penalty, that's designed to ensure compliance among multinationals, much like the European GDPR model.
It is. It has that same extraterritorial reach.
That sounds like an instant headache, but I know our sources mentioned a strategic implementation timeline. That must be some relief for global compliance officers.
It provides a necessary runway, yes. The full obligations for high-risk AI systems in key sectors like healthcare and finance won't actually take effect until 18 months post-effective date. So that's September 2027. And legacy high-risk systems are granted an even longer transition until July 1st, 2029. This is time you, the learner, have to strategically deploy your resources.
And if we look at the broader APAC context, Vietnam's framework sits in a pretty interesting place. Are other Asian nations adopting this kind of highly structured approach?
The broader regional trend remains quite diverse. While Vietnam is embracing a structured, risk-based model, many neighboring nations are leaning towards lighter touch, more business-friendly approaches. Japan, for example, has enacted an AI law but imposes zero financial penalties for breaches. They focus instead on voluntary guidelines and industry self-regulation.
This just confirms that for a multinational corporation, compliance is truly a patchwork quilt. You have to simultaneously manage Vietnam's specific mandatory deadlines and penalties alongside Japan's soft-touch guidance, alongside everything else.
Which is why when you're dealing with requirements, this fragmented mandatory local representation in one country, sector-specific transition timelines in another, and global revenue-based penalties in a third, You absolutely need a unified, centralized source for legal information. For comprehensive, organized legal and regulatory insight across complex jurisdictions, you need to rely on www.compliancehub.wiki. It provides the necessary insight to connect the dots between Vietnam's new AI law and the various regulatory shifts happening in every other market you operate in.
Let's zoom out now to the full global landscape that our sources describe, because the global rulebook is fracturing at light speed. We have these two massive regulatory poles pulling in opposite directions.
That's right. On one side, you have the U.S. administrative direction, which is staunchly embracing an innovation-first deregulatory stance. The policy focus has shifted away from prescriptive safety mandates, and instead it emphasizes removing perceived regulatory friction, clearing the path for investment, and ensuring AI development remains ideologically neutral.
A policy designed to maximize domestic competitiveness.
Primarily, yes. And that stands in direct tension with the other pole, the EU.
Right, which is the opposite.
The EU is the opposite. Prescriptive, enforcement-driven, and focused on control. The rollout and implementation of the AI Act is a global game changer. It imposes strict, technologically neutral safety requirements across the bloc, with severe penalties for non-compliance. Their strategy is centered on setting a global standard for trust and safety, even if it comes at the cost of immediate innovative speed.
So where does the UK fit in this dichotomy? Are they more European or American in their approach?
The UK is trying to carve out a strategic third pillar. They're selectively aligning with the EU on certain enforcement-heavy, prescriptive rules where legal certainty is necessary, like the Online Safety Act and the Cybersecurity Bill. But at the same time, they're pursuing pro-innovation divergence in key areas, notably through the Data Use and Access Act, which aims to streamline compliance and ease burdens for small and medium enterprises. They're looking for a competitive middle path.
What's genuinely challenging for businesses, I think, is that these regulatory boundaries are blurring. We are seeing a convergence of enforcement, meaning one mistake can trigger multiple investigations at the same time.
Exactly. This necessitates what corporate lawyers are calling a one-dossier mindset. A single algorithm change can now trigger scrutiny from privacy regulators, competition authorities, consumer protection bodies, and emerging AI regulators all at once. You have to build evidence and audit trails, your one dossier, to satisfy all of them.
Proving that the change adheres to data localization, competitive behavior, safety standards, and consumer fairness all at once.
Not at once. It's a huge task.
So, if you are a leader at a major corporation or you're advising one, what is the single most important consequence of this fragmentation for the C-suite?
The critical point is that AI is no longer an IT issue. It is a board-level fiduciary imperative. We are seeing a dramatic rise in corporate transparency around AI governance. The proportion of S&P 500 companies disclosing board oversight of AI or specific board-level AI competency, it jumped over 84% last year. If you don't have a clear, articulated strategy, investors and regulators will notice.
And as companies rush to articulate that strategy, there is this emerging enforcement flashpoint, AI washing. What does that look like in practice?
AI washing is the act of misrepresenting the capability, readiness, or safety of an AI system to get a competitive advantage or appeal to investors. It's essentially corporate puffery that crosses the line into fraudulent or misleading claims. For instance, the US SEC and FTC have both declared AI washing a core enforcement priority. We've already seen SEC cases brought against investment advisors for falsely claiming they used specific AI tools to make investment decisions, well, when they hadn't.
And the risk there is enormous because the EU AI Act includes provisions that could trigger fines up to 1% of global turnover just for misrepresentation. And that's on top of potential penalties from consumer protection agencies.
Yeah. It creates a tremendous legal exposure. Forward-thinking boards are mitigating this by adopting 3 pillars of effective AI governance, as outlined in our sources. First, navigating regulation, which means contending with the EU's Prescriptive Act, the fragmented U.S. state laws, and these APAC strategies like Vietnam's. Second, building strong internal governance, meaning a framework that ensures accountability and prevents AI washing across markets. And third, scrutinizing high-risk use cases, dedicating disproportionate attention to the AI applications most likely to create legal or reputational damage.
So it's clear that managing this dynamic global risk requires an integrated approach. The fragmented rules demand constant monitoring and an agile strategy across all 3 of those pillars.
Absolutely. Whether you are developing these mandatory governance frameworks using templates and legal summaries from www.compliancehub.wiki to track global deadlines, or you are implementing the rigorous, audible assessment controls recommended by www.airiskassess.com to prevent AI washing, forward planning is now a necessity. You simply cannot afford to manage today's AI risk with yesterday's siloed regulatory tools.
Before we conclude, we've covered the fragmentation of AI laws, but let's hit one critical underlying issue that this fragmentation is making even worse: the global landscape for data anonymization.
This is a massive strategic issue. Anonymization is a crucial enabler for global data flows and training models because truly anonymous data. It falls outside the strict scope of major privacy regimes like GDPR and many cross-border transfer laws, but what counts as truly anonymous is shifting fast, and regulators' expectations are rising dramatically.
Can you give us a concrete example of how regulators are pushing back on common industry practice?
Look at the US FTC. They've actively targeted misleading claims of anonymization. They found that certain standard industry practices, like hashing, converting personal data into seemingly unique one-way strings, still fall short of true de-identification. That hashed data can often be re-identified by combining it with other accessible data sets. The simple fact is that methods once considered safe are no longer sufficient to guarantee that data cannot be linked back to an individual.
And the courts are moving in a similar direction, making data scientists' lives much, much harder.
That's evidenced by key European rulings, like the CJEU case concerning data access. This ruling signals a move towards a more pragmatic, context-based standard. Regulators are now assessing whether data is truly anonymous based on the means reasonably available to the actor trying to de-identify the data, rather than requiring proof against some hypothetical, all-powerful third party. The focus is now highly contextual, meaning data that is anonymous today might not be tomorrow if new linking technologies emerge.
So what does this all mean for you, the learner, grappling with these accelerating risks?
It means that in a world of fragmenting laws and high-stakes enforcement against everything from IP infringement in Vietnam to AI washing in the US, the ability to robustly demonstrate that your data is genuinely anonymous and your high-risk AI systems are safely managed is far more than mere compliance. It determines whether you can legally, ethically, and reliably unlock the value of your data globally for training models and analytics. The biggest challenge in the digital economy isn't creating the AI. It's proving you can govern the technology legally and reliably across every single jurisdiction.
And that proof requires continuous vigilance. Active monitoring of key global policy developments, like the UK's new not materially lower transfer test under the DUAA or forthcoming CJEU rulings on the calculation of GDPR damages, is absolutely essential. These small legal flashpoints are where the global battle for digital governance will be fought in 2026.